Can anybody hear me? Hello?
We can hear you.
Oh, okay, good, good.
Sir, can you hear me?
Yes, ma'am.
Hi.
Yes, ma'am.
What's your name, please?
Sean Solat.
Thank you.
I'm not late. It's 8:30, correct?
No, you're cool. Yep.
Okay, cool. Oh, I got nervous. Ma'am? Oh, boy.
morning, Royce. How's it going?
Good. How are you?
I'm well, thank you. Hey, your client is here. Do you need a breakout room with her? Or are you set?
Yeah. If I could just have a brief breakout room, that'd be great.
Yeah, you bet. I see your dogs. It makes me so happy. Or
Yeah.
a dog. There, look.
No, there's two of them. They're floating around somewhere, looking for something to get into.
Okay. Are you gonna do it or do you want me to do it?
Oh, I'm sorry. I didn't know that you made me co-host already. I'll do it. Thank you.
Thank you.
Mhm.
Mr. Solak,
Yes, ma'am.
we've just been waiting for the court-appointed attorney to show up. Have you spoken to someone about the recommendations made by the probation department?
No, no one's talking to me.
I'm sorry, you said no one's spoken with you?
Yes, ma'am. No one's spoken to me.
Okay. My secretary has put a call out to the court-appointed attorney. Hopefully he'll get logged on soon so that you can have somebody review the recommendations with you.
Okay. I mean, I read them on my email. When they
Were
got
you looking,
sent an email, I read what it said.
were you looking for the assistance of the court-appointed attorney this morning, or were you looking to proceed on your own?
To be honest, I don't even think he's good for me, so I could just do it on my own, ma'am.
Well, Mr. Solak,
If
if
that's
you're
okay.
ready, I'll call the case.
Yeah, that's fine. We can do it.
Okay, this is 22BL006667OD. This is City of Belleville versus Sean Christopher Solak. Sir, let me apologize to you first. I was waiting. I've been here. I waited to come out because I was waiting for the court-appointed attorney. I was under the impression that you were going to use him this morning, but if you're going to proceed on your own, we can proceed with your sentencing right now.
Yeah, that's fine. That's fine. I didn't know he was supposed to come back down here. I'm sorry.
No, you're fine. You're absolutely fine. You started to say though that you read the recommendations
Yes, ma'am.
made by Stephen Hicks. Was there anything you wanted to say about his report or the events from September 25th, 2022?
The only thing is, I know that that's gonna be a lot of money, but I'm gonna do what I have to do. But I know he wants drug testing. I was just wondering for the marijuana because I had my medical card and I use it for PTSD and for me to sleep and eat. So I was hoping you could get me to still use that, but if not, then it's okay. I'll deal with it. This is it's like medicine for me.
There are two people on from the probation department and they'll address that issue in a moment. But Mr. Solak, the court has had the opportunity to read the recommendation that was made by Stephen Hicks. Again, this was a event that occurred back on September 25th, 2022 in the city of Belleville, where you were charged with operating while intoxicated with a blood alcohol of 0.09. You entered a plea of guilty to the reduced count of operating while visibly impaired on October 20th, 2022. And as is this court's policy, your case was referred to probation for a sentence recommendation. The court has received the recommendation, reviewed it in its entirety, along with the police report, your driving record, and your criminal history. And sir, because this is your third drinking and driving offense in the last 3 years, the court has some concerns and will adopt the recommendation of Mr. Hicks and place you on 18 months of probation with the oversight fees associated with that. That's $720 in oversight fees. Will assess a fine of $300, cost of $100. There's mandatory crime victims fee of $75, mandatory state costs of $50, fund fee of $20, $150 of restitution to the city of Belleville. The request is that you be placed on 60 to 90 days of alcohol monitoring, we'll say 60 days. Engage in substance abuse treatment beginning within 30 days and follow the recommendations from that program. Attend weekly AA meetings and submit documentation to probation as directed. Ms. Rapp, there's a request that he not purchase, possess, consume alcoholic beverages, which the court will adopt and submit to random testing after the alcohol monitoring. But on the issue of the marijuana card, did you want to weigh in on that?
The court doesn't have any objections for the defendant to use his medical marijuana. It's at your discretion, Your Honor.
Mr. Solek, based on your described need, the court will allow you to continue on with the medical marijuana card.
Thank you.
You're so welcome, sir. Resolve
when I
any
get
active
that-
warrants. I'm sorry.
No, go ahead. I'm sorry. I thought you were done. You first, ma'am.
Oh, no, I just was making notes before the file goes back downstairs. Resolve any active warrants you have and provide documentation to probation within 30 days that you have resolved it. There was a note on your file that you had a warrant out of Ohio for driving under the influence. So resolve that and anything else. What will happen next, sir, is that the probation department will be in contact with you because there will be paperwork for you to sign. And you will need to get the alcohol monitoring set up if you need assistance in getting into substance abuse treatment. But Mr. Solek, the purpose of probation is for you to be successful. This is not a trap. There's not a pitfall for you. If you need assistance over this next 18 months, all you need to do is reach out to the probation department and let them know what it is that you need to be successful. If you get halfway through that probationary period, so 9 months in, and you've done everything that you're supposed to do, provided the documentation, and the only thing left are your fines and costs, you could request to be discharged from probation early. Again, Ms. Rapp and Mr. Grant are here and available to you for what you need to do to complete your monitoring, your treatment, provide the AA documentation.
Okay.
You had a question, sir? I'm sorry, I stopped you before.
Yes. I definitely need to talk to the probation people. I do need help. And then the second one is, do I come to the courthouse to get that monitor?
Mr. Solek, I'm sorry, sir,
I don't know how
you're
to do
breaking,
that.
you're breaking up so much, I can't understand your question.
I'm breaking out, yeah.
Mr. Solek, if you're able to
I
hear
need to
me,
talk to the probation people, yes, and then for the ankle monitor, do I have to come to the courthouse? Yes.
We'll send everything to your email. And then if you have any questions, you can always come up and we can sit down and go through everything.
did you catch that, Mr. Solek?
Okay. Okay, cool.
Okay. Well, thank you for your patience this morning, sir. Again, the
I
court
don't know
wishes
why
you.
my phone's not working.
It might just be
Yes,
the
ma'am.
area you're in. No, I was just saying, if there's something
Yes.
else
Oh,
you
what's
need,
going on?
please reach out to probation. I think we just lost it too. Oh, no.
Can you hear
Yes.
me? Oh, I'm so sorry. My
Yes.
phone is being weird right now.
Nope, don't apologize, sir. I understand. Sometimes technology is not everything it's cracked up to be. But check your email
Yeah,
from
I
probation.
can't stand it.
Probation will be in touch with you, and again, reach out if you need something, okay?
Yes, ma'am.
Good luck to you, sir. Have a good day.
Thank you. You as well. Bye.
Bye-bye. This is 22BL007340D. This is City of Belleville versus Amber Bogus. Maybe your appearances, please.
Yep. Royce Nunley appearing on behalf of the defendant.
Ma'am, state your name for the record.
Amber Bogus.
Bogus, thank you. Today is the day and time set for sentencing in this matter. It was a defense date of October 14, 2022 in the city of Belleville, which time is Bogus was charged with operating with a blood alcohol content of 0.17 or more. She appeared in front of this court on November 17, 2022 and entered a plea of guilty to the reduced charge of operating while visibly impaired. As is this court's policy with drinking and driving offenses, she was referred to the probation department for interview and the development of a sentence recommendation. The court has read that recommendation along with the police report, driving record, criminal history, and the needs assessment. Mr. Nunley, what do you wish to say on behalf of your client?
We do have one correction that we would like to request be made to the PSI. It indicates in the PSI that she's drank continually or used alcohol since age 25. She wanted me to let the court be known that there was a period of sobriety from May or June of 2021 until February of 2022 when she was pregnant with her second child. She didn't want, the court or anybody to have the impression that, she was drinking or using drugs, while she was pregnant with her child.
Thank you for that clarification, Mr. Nunley.
Yes. As far as allocution, my client, this seems to be a really out of character incident for her. She doesn't have any real criminal record to speak of. She has a steady job. She works for her family business. They own that Apex Iron Works in Taylor, Michigan. She's worked there for 7 years. Her dad owns it. Her brother works there. She does the office management there. Like I said, she has no real criminal history to speak of. This is a very out of character incident for her. And my impression of her, getting to know her and speaking to her throughout this, I don't believe that this court or any other court is going to see her in front of them again for this sort of matter, at least from my impression of her. She seems to be remorseful and understands that, she made a mistake and she has to face the medicine. So that being said, I think that the recommendation by probation is reasonable, and we just ask the court adopt the recommendation.
Thank you, sir. Mr. Nunley, you've been in front of me enough to know that I'm not a big lecturer when it comes to the sentencing. But when I read a police report that has a BAC of 0.31, it indicates that your client took out 4 mailboxes. I immediately go to the calendar. I looked at this was a Friday afternoon at 12 o'clock. This could have ended so much worse with those 4 people checking their mailboxes and could have been little kids at the curb. And that's a concern. And when you say that this is out of character for her, I'll take you at your word, but it is, when you talk about public safety, and you talk about the dangers of drinking and driving, these are the type of incidents that make people want the courts to crack down on people who shouldn't be on the road. That being said, that's the only lecture of the morning. The court will adopt the recommendation of Stephen Hicks, place the defendant on 9 months of probation, assess the oversight fees associated with that. That's $360. Fine of $300, cost of $300, $75 crime victims fee, $150 of restitution to the city of Belleville, mandatory state costs of $50, mandatory fund fee of $20. Did I say crime victims fee of 75? That's a total of $1,255. Ms. Bogus reported to the probation department that the 4 mailboxes had been replaced, but there was no documentation provided. So if any of the 4 residents presents bills or requests to have the mailboxes restored, the court will take that up at that time. She will complete 48 hours of community service with documentation to the probation department as directed. Ma'am, if you don't already have a relationship with a community service nonprofit that you, with a nonprofit that you can do your community service with, reach out to the probation department. They can provide you a list of places. Attend a level 2 alcohol education program or engage in outpatient treatment beginning within 30 days of today's date. Follow all recommendations from that program and provide documentation to the probation department. Do not purchase, possess, consume alcoholic beverages or controlled substances without the court's approval, and submit to random testing a minimum of twice per month or as directed by probation. After 3 months, that may be reduced. Make payments, equal monthly payments of the fines and costs that this court has imposed. And ma'am, if you were listening when I was talking to the previous defendant, this court wants you to be successful at probation. If you get halfway through your probationary period and the only outstanding issue are your fines and costs, you may request early discharge from probation. And I would suggest that you not wait to begin that community service. You begin it as soon as possible. If you have any hiccups in the probationary period, please reach out to the department so that they can provide you the support you need to be successful. As Mr. Nunley indicated, it is this court's hope that we don't see you again and that you don't appear in any other court with a similar issue. Anything else this morning, Mr. Nunley?
Nothing further, Judge.
Ma'am, the probation department will be in touch with you. There'll be paperwork for you to execute. Have a good day and good luck to you.
Thank you. You as well.
Thank you, ma'am.
See you, everybody. Happy New Year to you guys.
Same to you, Mr. Nunley.
Happy New Year.
Happy New Year, Royce.
See you.
Hey, good morning, Sammer. How are you?
Good morning. Did Mr. Solek arrive today?
Yeah, he arrived and he did it on his own.
All right. Well, thank you guys very much.
Yep, yep. Happy New Year, Sam.
Happy New Year to you and your family, guys, everybody.
Thank you. Bye. Well, good morning, Josh.
Good morning.
You're looking good. Don't worry about it.
First time I've looked in the mirror in the morning, I'm like, oh boy. Looks like I just got Mr. Terrence Barney, I believe, today.
Yeah, yep. At 9:30. Yep. Okay. Just gonna leave you where you are.
You guys got any trials today, or is it just the morning?
No,
docket?
this is you are it after 9:30. Judge Martin's done. Pretty quiet in the court today.
Good. Nothing wrong with that this week.
Nope, I'll take it. You got that right. Good morning, Mr. Leonard. You're muted.
Can you hear me now?
Yep, I sure can. Good morning.
Good morning,
Hi.
Judge.
No, this is Mary Ann, the clerk. Is this your client right here who just signed on?
It looks like him. The picture's pretty small. Mr. Parmalee, is that you?
Yes, yes.
Okay, great. Are you ready? Do you need to speak with your client? Or are you ready for the judge?
No, we're ready.
Okay, thank you.
Can you see me okay?
I
Judge,
can.
okay. It's not all dark or anything?
Nope.
Okay.
This is 22BL00637A, City of Belleville versus Joseph Michael Parmalee. May I have your appearances, please?
Yes, Your Honor. This is Joseph Parmalee. Good morning.
And Your Honor, for the record, my name is Edwin Leonard. I am Mr. Parmalee's attorney. Today's the date and time set for a sentencing in this matter. Your Honor, my client previously pled guilty to impaired driving. Judge, I have had an opportunity to review the pre-sentence report that appeared, and I would like to address the court regarding, excuse me.
Thank you. Before you begin, Mr. Leonard, just so we have a clear record, there was an offense date in this case of September 8th, 2022, again, out of the City of Belleville, at which time Mr. Parmalee was charged with operating while intoxicated. He appeared before this court on November 17, 2022, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy with drinking and driving offenses, the case was referred to the probation department for interview and the development of a sentence recommendation. The court is in receipt of that recommendation, has reviewed it. It's in its entirety from Stephen Hicks, read the accompanying police report, Mr. Parmalee's criminal history, Mr. Parmalee's driving record. Mr. Leonard, what was it that you wanted to say on behalf of your client, sir?
Well, Your Honor, first off, let me say that the factual information in the report is all basically accurate. I think there's some minor misunderstandings. I would like to address them. And there's what I view as an omission. My client, Judge, you and I spoke previously in person when I was at court, and Mr. Nolan is aware of this. Following my client's arrest, Your Honor, at his own expense, he went inpatient at Pearl West, which is an inpatient alcohol treatment facility in Denver. And he completed a 30-day program there. When he left there, he went into a 3-quarter house and was there for another 7 weeks. He was then allowed to leave the 3-quarter house, and he is currently residing in Jacksonville, Florida. He attends AA once and twice a day. He's gone to 130 something meetings since Curra West. It's my understanding, because there's no mention of this in the probation report, but it's my understanding that my client did mention it to the probation officer, and that the probation officer said he had no verification of that. I would submit, Your Honor, Mr. Nolan knows this. I submitted the proof of his attendance to Mr. Nolan. Mr. Nolan saw all of that before he made this offer to the reduced plea of driving. And so my client's in, he sees a counselor. How often are you seeing a counselor, Mr. Parmalee?
3 times a week.
And you're going to AA once and twice a day, is that correct?
Yes. I don't miss a day.
Your Honor, so obviously I believe that that information is pertinent and Your Honor should know about it. There is also a reference in the report on record status saying that the defendant is on probation for disorderly conduct from Judge Oakley. And I'm not sure if that's true. My client was pled guilty to this in front of Judge Oakley. Judge Oakley assessed fines and costs, did not put him on probation, just said to pay the fines and costs. And Judge Oakley was aware of my client going at his own expense into treatment and his follow-up. In a nutshell, Your Honor, the report also indicates it's a little bit confusing whether my client thinks he has an alcohol problem. And I invite you to ask him. He's an admitted alcoholic. I think he got a little confused in some of these questions. He's an admitted alcoholic. He knows that. But he drink in social occasions primarily. But he doesn't stop when he drinks. He drinks too much and he gets in trouble. Every time he's ever been in trouble with the police, he's been intoxicated. And that comes as no surprise to me, and I'm sure it comes as no surprise to Your Honor that that would be the case. When you look at these offenses, disorderly person, disturbing the peace, all of this stuff is alcohol related, and he's finally made, I think, a very good faith effort to come to grips with it all. And so I want to be clear on that. Your Honor, my client is currently living in Jacksonville, Florida. His employer, DMS Moving Systems, is affiliated with Allied Van Line. My client was a driver for them. Because of this offense, of course, he has lost his CDL. But the company thought enough of him to keep him on. Your Honor, I'm getting a picture from someone other than my client on the big screen here. I can't tell if
There's
you
somebody else. There was somebody else that joined us on a later scheduled
Right.
matter.
As I was saying, I'm sorry, Your Honor, for the interruption. I've spoken with my client's employer, and my client's employer has kept him on as a laborer because he values my client's services. Apparently, there's a lot of skill involved in working for a moving company and being a mover. I guess I didn't really know that. And Mr. Parmalee is apparently very skilled. His boss doesn't want to lose him. So it's the same employer he had when he was here in Detroit. His employment takes him out of town for weeks at a time, driving around the country in a Allied Van Line truck. Now, he doesn't drive, but he's the laborer, the loader, unloader, takes the grand piano into the house, et cetera, et cetera. So some of the recommendations, I don't know how to accommodate these. In my experience at scheduling ETG tests, just around anywhere in the United States might be a problem, and I don't want to see my client mess up. I don't know if there'd be any alternative, maybe a handheld system of some kind where you could take breath tests in lieu of that recommendation. And all of the other things. I mean, he's in alcohol treatment. Obviously, he can't purchase any alcohol or have any drugs. There was a statement in there about he denied any use of drugs. Your Honor, my client told me that he smoked marijuana when he was a youngster. In 2014, he was in a car that was stopped. Other people had marijuana on him. He wasn't smoking that day, but fortunately for him, I guess, marijuana is not his problem. Alcohol is his problem and always has been. And I'd ask you to consider these factors. I think he's making a very good faith effort. on his own behalf to overcome his substance abuse problems. I think he'll obey whatever conditions Your Honor finds to be appropriate.
Thank you, Mr. Leonard. And I do remember having the conversation with you because your client had 2 cases out of 2 different jurisdictions, and the effort was made by the Van Buren Township prosecutor to be available on a day so that pleas could be taken in both courtrooms.
That's
and
correct.
Mr. Parmalee's issues could be resolved. And this court's concern, well, not to be duplicative of the steps that Mr. Parmalee has taken to address his issues since September 8th, 2022. In preparing for the probation docket, I read every single piece of paper in the file. And I read a police report that indicates that your client driving westbound, the officer was driving westbound in the area of East Huron River Drive and South Liberty. Observed a vehicle turn westbound from Angola Street onto East Huron River Drive. As I was driving toward the vehicle, I noted it to be in the eastbound lane. The vehicle was traveling toward my clearly marked police vehicle in a manner which required me to slow down and move toward the shoulder to avoid being involved in a collision. As you get further in the police report, Mr. Parmalee very clearly indicates to the officer, I'm in trouble again. This is another DUI, and he's found to have alcohol on his person. I say all this to say that part of probation and part of a sentencing is to deter someone from engaging in the behavior again. Mr. Parmalee does not have the highest BAC that this court has seen this morning, but it is troubling that this is his 2nd drinking and driving offense. The last one, it's been some time, but it's just a concern. And when part of your allocution on his behalf includes a statement that he knows he's an alcoholic, that is troublesome. But this court will adopt the recommendation of Stephen Hicks in part. Place Mr. Parmalee on 12 months of probation, along with the oversight fees of total of $480 for the oversight. Set the fine in this matter at $300, cost at $100. Crime victims fee is $75, mandatory state cost of $50, fund fee of $20.
I'm sorry, Your Honor,
reimbursement
what
bail
was, Judge, I'm sorry, the electronics didn't cooperate. I got as far as the state fee of $50. What was the next one?
$20 fund fee, $150, $20 fund fee, $150 restitution to the city of Belleville. That's a total of $1,175. Place Mr. Parmalee on 30 days of alcohol monitoring. And the recommendation is that he engage in substance abuse treatment beginning within 30 days and follow the recommendations with documentation to probation. But Mr. Leonard, I heard you say that that documentation had been provided to the prosecutor for the city of Belleville. That information has not been supplied to this court's probation department. So if either you or Mr. Parmalee would forward that information to the probation department that shows that Mr. Parmalee has engaged in substance abuse treatment and follow recommendations since this offense date, the court will review that and could take that as satisfactory for completing item 7 on that list of recommendations. Again, not purchase, possess, consume alcoholic beverages or controlled substances without this court's approval during the probation. You made an indication that you might request a handheld device to capture.
The 30 days of alcohol monitoring. And I guess I'm just wondering, is that how we would monitor him? With a handheld device, or how did the court do that? How can my client?
That's why I was stopping and Ms. Rapp turned on her camera because she heard the question coming, how to best accommodate Mr. Parmalee as he moves about the country working.
So the alcohol monitor is a breathalyzer, so it is something that you would blow into 3 to 5 times a day to monitor that.
So it's a handheld device of some kind.
Correct.
I'm familiar with those. Again, I've got somebody else on the screen here.
It's our 9:30 case. Your client is still there. I can see Mr. Parmalee clearly.
Yes, Your Honor, I have proof that he attended, that he went inpatient at Curl West and was discharged. Mr. Parmalee, do you have proof from your counselor that you can provide to the court?
Yes.
So that should not be a problem for you?
No.
And you'll call the probation officer and find out where to send it?
Yes.
Your Honor, I want to make sure so my client understands. You've ordered that he, I'm not sure if you're ordering that he continue counseling or that he submit proof of the counseling that he's already done.
I said that I would adopt paragraph 7, that he engaged in substance abuse treatment beginning within 30 days of today's date. But if he were able to present proof that he had engaged in the treatment through the program that you said he entered and that you submitted to, proof that you submitted to Mr. Nolan, if Mr. Parmalee submits that to Ms. Rapp and is satisfactory to her, the court will take that as satisfaction of item 7, the substance abuse treatment. I don't want Mr. Parmalee to repeat what he's done since the date of this offense.
Oh, no, no, I know that.
Thank you, Your Honor.
We're on the same page, Mr. Parmalee. And as for the ETG testing once a month, that will start after the conclusion of the alcohol monitoring. And Mr. Leonard, the probation department will send documentation to Mr. Parmalee that he needs to execute and return and assist him in getting connected with the alcohol monitoring and the request for the ETG. And you weren't on during the earlier sentencings, Mr. Leonard and Mr. Parmalee, but this court's desire is not to see you again, for you to be successful in probation. And between Ms. Rapp and Mr. Grant, there will be support available to you. If you have any questions about the documentation that's been requested or the orders of the court, all that needs to happen is an email or a phone call to Ms. Rapp or Mr. Grant, and that's from the probation department, and they will assist you in being successful. Again, the probation is just 12 months, sir. If you get halfway through your probationary period and you've done everything except pay your fines and costs, the court will entertain your request for early termination from probation. And Mr. Leonard, if you have any questions about the recommendations or what the court has adopted this morning, again, Ms. Rapp is available.
The only questions I have, Your Honor, is I understand he's got to submit the proof of what he's done. I don't know if Your Honor means that if he submits that he's done, he doesn't have to still go to counseling, or whether you want him to continue to go while he's on probation.
What I'm saying, Mr. Leonard, and maybe I'm not saying it succinctly enough, is that Mr. Parmalee, the information that you submitted to Mr. Nolan on behalf of Mr. Parmalee has not been submitted to the probation department, that he has engaged in this counseling and attended these AA meetings. The court is saying submit that information to Ms. Rapp using the email address that Mr. Parmalee has for probation department. Ms. Rapp will review it. And if it's satisfactory to her, it's satisfactory to this court, and that will satisfy paragraph 7, the substance abuse treatment.
All right. I'm hearing you, Judge, I'm dense today. You got to excuse me. I apologize to you, but I'm hearing you to say that would be the completion of his treatment. And in all candor, I mean, we'll do that. We'll send it in, and the probation officer, I guess, will recommend to the court whether he continue treatment or whether or not that's enough. Would that be?
I'm kind of confused too, Your Honor. How do I go about getting this thing? I don't even know what it is. The
probation department will explain that to you.
Okay.
Mr. Leonard, maybe, I'm sorry, Mr. Parmalee, I am going to cut you off. Mr. Leonard, maybe I misunderstood you. I understood you to say that Mr. Parmalee on his own entered treatment after the date of this offense, correct?
Yes, that is correct.
And what I'm saying is if he has already started treatment in response to what happened in September of this year, the
Yes.
court would not order him to start a new treatment program.
I
If
see.
he is in treatment and has followed the recommendations, just show proof to the probation department. He doesn't have to start a whole new program. Just show us what you've been doing since September. And if it's sufficient for Ms. Rapp, who is well versed in, she's involved in this court's drug treatment program, drug treatment court. She knows what to look for. She knows if the program that Mr. Parmalee has been engaged in is satisfactory for her purposes. And she'll say to me, she'll send a report up to me, a memo up to me that says, we received this from Mr. Parmalee. He satisfied the court's order that he engaged in treatment by virtue of what he's already done.
And I'm assuming she'll
And if
tell
it's
you
a-
whether it's to continue treatment. That's what I'm getting at. I don't think, I'm guessing nobody's gonna discontinue it.
Well, I would think that whatever they sent to, they being the treatment, the counselor he's seeing, I'm sure that whatever they send will say what he needs to do. It's not Ms. Rapp that orders treatment. It's what his counselor says he.
All right, so
Mr.
he should
Parmalee
follow,
needs.
he should continue to follow the recommendations then. That
That's
clear,
exactly,
okay. That
no,
does.
that's
clear-
exactly what I said. I said engage in treatment and follow recommendations from the program and provide that documentation to the probation department.
Yes, yes, I'm sorry for my,
Mm-mm.
I'm a little slow this morning.
Mr. Leonard, you're not slow, you're just thorough, and I'm sure that Mr. Parmalee appreciates that.
Karen, thank you very much, and I would like to thank you for all of the courtesies you have extended on Mr. Parmalee's behalf to me in connection with this case. And I should call Ms. Wrap up and get a fax number to send her the appropriate documentation. Way to
Do
go.
you want it by fax or email, Ms. Rapp?
I'll send my email in the chat so everyone has it.
Thank you.
Thank you very much, Your Honor.
Thank you very much. And
Your
I'm
Honor,
gonna,
You're so welcome.
have a blessed new
Mr.
year, Your Honor.
Parmalee, good, you too, sir. Mr. Parmalee, good luck to you.
thank you very much, Your Honor. I appreciate that. And have a happy new year.
Happy New Year to you, sir.
All right, bye.
Goodbye.
Goodbye, sir.
Goodbye.
This is 2200790D. This is Van Buren Township versus Terrence Barney. May I have your appearance, please? You're muted, Mr. Hadley.
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of probationer defendant, Mr. Terrence Barney. I did have a chance to speak with Mr. Barney, Your Honor. If I could just have a quick moment with Miss Rapp in a breakout room.
Absolutely.
We'll be brief. Shan, you want to go to room 2?
Yeah, I don't think I can go in. You have to,
Let's see if I can.
Ms. Rapp, your co-host, you should be able to move yourself.
yep, nope, I see it now.
Mary, I'm gonna step off while they're talking. I'll come right back out as soon as they're ready.
Okay.
Was that sufficient time with Ms. Rapp?
It was, Your Honor. Thank you. We had a nice visit.
Thank you. That being the case, this case is before this court this morning on a notice of violation of probation from Shannon Rapp of the Probation Department. That violation notice is dated December 29, 2022. It indicates that Mr. Barney has failed to provide documentations of substance abuse treatment, failed to enroll in drug and alcohol testing, failed to maintain his payment plan. It indicates that on July 23rd, 2022, Mr. Barney's SoberLink device reported BAC readings of 0.118, 0.247, and 0.153 between 1 p.m. and 1:28 p.m. Mr. Barney was previously scheduled to be here for show cause back on October 24, 2022, failed to appear, and a bench warrant entered for his arrest. He has appeared this morning by Zoom. The court will recall the warrant. That being the procedural background, Mr. Hadley.
Thank you, Your Honor. After having a chance to speak with Mr. Barney and Probation Officer Rapp, it's our intent, Your Honor, that we would go ahead and plead responsible to the alleged probation violations with a small explanation as to kind of our position on that. SoberLink, we understand the people's position that it does appear that there was some alcohol use that date. Ms. Rapp and I did discuss sort of the unusual bell curve of those readings. While there may be some contesting as to what the actual BAC was, we recognize it does represent that there was some use. Briefly, Your Honor, Mr. Barney has had a really rough run of it recently. Just to give the court kind of some factual background, he had a tragic family loss. His son's been accused of taking the life of his wife. Mr. Barney had attempted to move down to Alabama to be with family and kind of take care of business, if we will. To update the court and Ms. Rapp, he has not moved to Alabama. However, he has relocated to South Point, Ohio. It's in the southern portion of Ohio. He is working, and my understanding is he is maintaining sobriety. So that's sort of where we're at. Now, what Ms. Rapp and I were discussing is kind of what do we want to do from here, and what's a workable solution to this in light of the responsibility plea. We would like, Your Honor, if this court would entertain the idea of maybe setting it out for 60 days for a status conference update to allow Mr. Barney to try to secure somewhere down in the South Point, Ohio area where he can obtain drug testing, alcohol testing via like an ETG. What we would recommend to Mr. Barney is that he would contact the local court probation department down in South Point, Ohio, find out what agency the court uses for testing, and we would get him returned to a testing policy, testing procedure where those results can be sent up to Ms. Rapp for verification. As well as I mentioned, he is back to work, so I know he has a balance of 1,205. We would ask that the court, again, set that out for 60 days to allow him to chip away a little bit at that. Mr. Barney, can you hear us okay, sir? You're on mute, sir.
Okay, can you hear me now?
Yes, we can, sir.
Yes, sir. Ms. Rapp, you were able to hear Mr. Hadley's request. Is that the position of the probation department?
Yes, Your Honor, we're requesting a 60-day adjournment so we can get back on track.
And Mr. Barney, were you able to hear what I was telling the court today about you needing to find someplace down in South Point that you can resume the testing with?
Yes, I did.
Okay, it's going to be your responsibility to find that and locate that. Ms. Rapp has graciously kind of extended this period. Is this something you're going to be able to comply with and get a hold of the court down there?
Yes, I can.
Very good. Your Honor, with all that said, we would humbly ask that you would adopt our recommendation in light of, again, the circumstances and kind of the good faith effort that Mr. Barney would like to put forward.
Thank you. Ms. Rapp, having no objection, the court will accept your plea of responsible to the violation Mr. Barney will adjourn this matter for 60 days. The probation department has that schedule, and we'll send notice to your updated address. In the interim, you are to contact the local court to establish your testing and treatment. You will resume your payments directly to this court. Mr. Barney, have you verified this Ohio address or provided the Ohio address to the probation department this morning?
Not yet, Your Honor. Mr. Barney, can you please state on the record for Miss Rapp what your current address in Ohio is?
Well, I'm living at the Country Hearth Hotel in South Point, Ohio. I don't right off know the address, but that's
What was the name of it, sir? I can look it up real quick.
Country Hearth Hotel in South Point, Ohio. It's on Highway 52.
Miss Rapp, I'm getting a 70 private road,
That's it.
number 302, South Point, 2 words, Ohio, and the zip code there is 45680. Mr. Barney, do you have a room that you've been staying in consistently, or have they been moving you from unit to unit?
I've been moving around from unit to unit because I keep having problems in the bathrooms with the toilets.
Understood. We're gonna have any correspondence that's sent to the hotel will have your name on it. You're just gonna need to check with the desk there on a regular basis to make sure that you're receiving your mail. Okay, sir?
Okay. So then let's do it like this then, because I'm gonna move from that hotel and I'm gonna move to Kentucky, which is right across the bridge. So I'd rather the mail gonna be sent to go ahead and send it there because I'm gonna come out of this hotel I'm in. And the hotel that I'm gonna move to is called the Knights Inn. It's called the Knights Inn in Ashland, Kentucky, which is
Mr.
right across
Barney?
the bridge. Ma'am.
Mr. Barney, do you have the email address and phone number of this court's probation department?
Yeah,
Yes,
I was just
ma'am.
trying to verify his email.
Okay, Mr. Barney, here is this court's concern, and I'm going to put it out there so Mr. Hadley will hear it at the same time. You signed an order of probation that indicates that you will not leave the state without consent of the court. You have moved from Michigan and are now indicating on the record, after Mr. Hadley has been kind enough to look up the Ohio address, that you're going to move to Kentucky. So if you're not going to take probation seriously, we can end this hearing a whole different way.
No,
I'm happy to do that. But sir,
I'm ready to take it.
please. No.
apologize. Yes,
What
ma'am.
I will say to you is, when you move, you are required to let the probation department know where you are. It takes a second for you to send an email
Okay.
or call the court's probation department while you're standing in front of the building and you can see the address and say to Ms. Rapper or Mr. Grant or Ms. Randolph, hey, this is Mr. Barney, this is my case number, this is my current address.
Yes,
We
ma'am.
come back in 60 days, it won't be a good enough excuse that you've moved and you didn't get a copy of the notice, because I'm telling you how to be in communication with the court. The court wants you to be successful on probation, and when you decide that you're going to disobey the rules of the court, the orders of the court, by moving without permission, by consuming alcohol when that's what brought you to the court's attention in the first place, by not getting treatment, by not making payments, I understand that there have been some life issues. You wrote a letter to this court in September. I read all 4 pages of it, and I looked into the allegations regarding what caused you to begin the spiral regarding your son and your wife. And I understand that. And people have bad days, but there are consequences to your bad days. That's the end of the lecture for you today. You know how to be in touch with probation. Please do it. Otherwise, 60 days from now, if you're not here or you're here and you haven't done what you're supposed to do in terms of being in communication with a local court, whether it's Ohio or Kentucky, to establish treatment and testing and everything else, I'm sure Ms. Rapp will willing to go along with the recommendation from the defense attorney and will be suggesting that in recommending that this court in order a different kind of response to your failure to comply with the court's order of probation.
Okay, Your Honor.
Was there something else, Mr. Hadley?
No, not at all, Your Honor. Thank you for your time and patience today. Same to Ms. Rapp. Mr. Barney, good luck with everything. And please, like the judge said, just stay in communication with the probation department, okay?
I will.
All right. Have a nice New Year, sir.
Anything else, Ms. Rapp?
No, Your Honor.
Thank you.
Thank you.
Have
Happy
a
New
good day
Year.
and good luck to you, Mr. Barney.
Thank you, Your Honor.
Mary Ann,
Yes, ma'am.
take us down, please.
Okay,
Thank you.
you're welcome.
That concludes